Yeah, a warm welcome on behalf of the World Wind Energy Association to today's webinar. It's a great pleasure to welcome you to the webinar Litigation for Mitigation Constitutional Dimensions of Renewable Energy and Climate Change, which is done in collaboration by the WWA Legal Working Group, the European Renewable Energy Federation, in partnership with Taylor Wessing, and as usual also supported by our supporter, German Profec Ventus. Before we start with the webinar with our speakers, let me just introduce you some general rules. At first, let me mention that this is a public event. It means that it's not only the participants here, but it's broadcasted live on YouTube. We're also recording the webinar, and the recordings will be made available later on our platforms on YouTube as well. So if you speak, if you show your face, if you switch on your camera, please be aware this is public. With this, again, a warm welcome to all our speakers, to our guests here. And then I would like to hand over to the president of the World Wind Energy Association, Peter Ray. Peter, it's my pleasure to hand over to you to welcome our participants.
Well, thank you very much, Stefan, and welcome to everybody who is able to join our webinar, which is one of a series of webinars, but perhaps for me, one of the most interesting that we've had, because the subject matter is not only wind, which is something particularly important in my view, and which I've had a lot of time to be involved with, but also as a long-term lawyer, I find this development one which I'm looking forward to hearing the various views. It's a situation where litigation for mitigation is something which has become very much to the fore in the past few weeks, with two decisions which have been taken by courts in Germany and in Australia. There may be more elsewhere, but those two have received particular publicity, and they are very interesting new developments in the law. It's important that we can discuss some of the questions which have been listed, and those who've been enrolling in this would have seen the questions which are going to be dealt with. I think we have the speakers who can carry the interest of everybody, plus the information that's necessary for us to get some better ideas about the answers to the questions which have been raised. I'll leave to them speaking about the detail of the cases and the law generally, but I would like to say that breaking new ground in the law is always a challenge. It's interesting, it's exciting. But it sometimes takes a lot of time. And I don't think that these two cases, which have been receiving a lot of publicity recently, very recently, I don't know how long it will take for them to be adopted in other parts of the world, or even in their own countries, where no doubt there'll be some other appeals or ways of endeavouring to challenge those decisions. Life is like that. But I think we're breaking new ground. It's an exciting event, and I look forward to hearing what everybody has to say. I again say thank you to all of the speakers. Thank you to those who are participating as part of the audience, and I look forward to that as I hand it back to Stefan to commence the webinar. Thank you very much, everybody, for your participation.
Thank you so much, Peter. Greetings to Australia. It's a pleasure. We have several people today here joining us from Australia. I'm one of the few speakers, or as your co-moderator, who is not a lawyer, but it's my pleasure to introduce my fellow co-moderator, Mr. Tobias Nutt. Tobias, you are coordinating the legal working group of the World Wind Energy Association. You're personally a lawyer by background as well, working in different positions as a lawyer in the sector of wind energy, but I know that your interest, your passion goes beyond wind energy, in renewable energy in general. Tobias, I hand over to you to introduce the topic to us.
Yeah, thank you, Stefan. Thank you for the flowers. Yeah, my name is Tobias Nutt. I'm a lawyer from Germany. I'm working in the renewable energy business since 2006, and read a book from Hermann Scher in 1993, and since then I really like the renewable energy idea of decentralized power, and so that's the reason why we're here. Sean, could you please open my short presentation to start? Sean?
Yes, I will do it now. Just a second.
Yeah, thank you. So why we are here, because we have some decisions of courts regarding climate protection. We will speak today, I think, about the German Federal Constitutional Court, about a decision of a Dutch court and also of an Australian court. So can I change it also? Do you give me access, or how do we proceed?
No, if Sean shows it, then you must just say next.
Okay. Yeah, so the question for me was legal action to protect the climate, and I say yes, please. Next chart, please. The German decision of the Constitutional Court, was who's responsible for this decision? It's this young people. You see the source under the pictures. It's young people, and it's the next generation who will really face the problems of climate change. Next chart, please. And so just to give you an overview, what the Federal Constitutional Court of Germany said. Well, he said that the provisions of the Federal Climate Change Act from 2019, that they are incompatible with fundamental rights insofar as they lack sufficient specifications for further emissions reduction from 2031 onwards. So the court decided that the government, that the legislation wasn't good enough, and that the fundamental right, which is a position in Germany which is quite high, was violated, and therefore the decision was pronounced. I've copied in the official press release in English at the bottom, so I think this would also be interesting for the people who aren't aware, who don't know the judgment so far. Next chart, please. To work more on the legal issues, the legal topics, you find a very interesting summary of two lawyers who worked on the case. It's Dr. Roda Verheyen and Dr. Ulrich Wollenteit. So it's also in English. It's 5 pages. You found this on the German Watch internet site. I think that's also interesting for you to work after our webinar on the topics and to better understand the legal issues. Next chart, please. I've just summarized for the participants a little bit the issues I think which are important. So first, it's a question: who's able to file a complaint? Can this be individuals, association, communities, maybe states, or even companies? I think that's interesting here in the German decision. It were individuals with fundamental rights who had the right to file a complaint, and then it's a question of material law. Well, what's written in the law? Are there any provisions to protect the climate, to reduce CO2 emissions on a national, regional level. And the German court decided that the existing law violated the duties of the state. Then I think it's very interesting, how do you take this legal action? Will you go to or file your complaint concerning public law, constitutional law, or for example also civil law? For example, Rhoda Verheyen, she has also filed a complaint against RWE, and this is on a civil law basis, and they are asking for liquidated damages. That's also very interesting. So next chart, please. Yeah, and then that's question, well, against who is the complaint filed? It's a state, federal state, region, or, and that's relatively new. It can also be a corporate company. And on 26th of May, so really new, well, Royal Dutch Shell, the big oil company, was ordered to reduce 45% of its CO2 emissions by 2030. And I think that's okay to file a complaint against a state. I think everybody would say, yeah, this should be possible. But to file a complaint against a special company, I think that we were not used to it. And from a legal point, it's maybe a little more difficult, but as we see, the Dutch court decided that Royal Dutch Shell has its responsibility concerning the climate change. At the moment, the Dutch court decision isn't valid. It can be asked in another court decision. So we will see how this goes on. So it can, Royal Dutch Shell can appeal the court decision, and probably will do it. So next slide. Yeah, that's the last slide. When I prepared the webinar, I said, well, what's important? And me, as a father of two daughters, I thought about a speech which I heard in 2002 from Jacques Chirac, French president of the French Republic. Well, he wasn't that environment friendly, but in 2002 I really was surprised when the guy said at the World Summit on Sustainable Development at Johannesburg, and he started his speech with these words: "Mr. President, ladies and gentlemen, our house is burning down and we are blind to it." And I think that's summarizing the situation. Most people, they acknowledge climate change, and it's human-made due to the burning of fossil fuels. And the question is how we stop this. And I think on the one hand, yeah, we can think that the politicians and politics will help us, will find the solution, and I think with the last decisions in Germany and the Netherlands and also Australia, I think it becomes clear that, well, we have also to take legal action. And I think this approach is very, very interesting concerning to ask the companies to take responsibility. And yeah, and if they think that they have the right to pollute and burn our house, I would say, well, very probably we have the right to take legal action against this behavior to stop this development. Yeah, so my short summary and introduction. So next slide. So thank you for listening to me, and I'm really glad to have today very interesting people, with who we are working together from the legal working group since quite a long time. Carsten Bartol and Hartmut Kahl and Dörte Fouquet. So I would like to introduce Hartmut Kahl from the foundation for environmental energy law in the southern part of Germany. You're based, and Hartmut Karl worked as a lawyer in a big law firm, and well, one day he decided to say, well, I want to do research concerning renewable energies and so on. And yeah, you're working since how long, Hartmut, now for the foundation?
Almost 10 years.
10 years. Whoa, time is passing by. Yeah, you had your first speech in 2014 at our legal workshop with Taylor Wessing at Hamburg. So time is going by. So yeah, maybe you present yourself a little bit and then go on, and I'm happy to listen to you and your presentation. Thank you.
Yeah, thank you. Good afternoon from Berlin. I'm in Berlin now. I'm happy to be invited to introduce you into that historic decision by Germany's Federal Constitutional Court. I'm happy to see many old and dear friends among us, but also a lot of new colleagues interested in that topic. I have an excuse in advance. I have to leave right after my presentation, and that isn't because I wouldn't be interested in the other presentations, but my next online session is just ahead. So sorry for that. I have to leave early. The decision by Germany's Constitutional Court is quite historic. It's really a milestone in recent constitutional history. And yeah, the decision is quite long. It has over 100 pages, so one is tempted to conclude too long, didn't read. But actually, a lot of us in Germany very diligently studied that judgment. And right now, I try to give you in a nutshell what are remain topics, remain reasons of that decision. Tobias just mentioned that the complaint was filed by dozens of complainants, most of them children or minors. And they said in their argumentation that Germany's Federal Climate Change Act is insufficient to reach the Paris obligations from the Paris Agreement, and therefore the federal government, federal legislator, infringes our fundamental rights. So that was the main argument in this complaint. And that is why I just want to give you a short introduction to that Climate Change Act. It's a quite new act, it's just 2 years old. And the Climate Change Act pursues the long-term goal of greenhouse gas neutrality by 2050. And greenhouse gas emissions must be, according to that act, be gradually reduced by at least 55% by 2030. And it sets out annual allowable emission amounts for various sectors: industry, energy, heating, mobility, agriculture, and so on. And these amounts are in line with the reduction quota for 2030. And now, the surprising fact, provisions applicable beyond 2030 were not contained in this act. So it had really a gap of 20 years between 2030 and 2050. That's important to know. And the first prong, so to say, the the decision is based on, as Tobias said in his introduction, is based on fundamental rights. And so we have in the German constitution, which is called Basic Law for historical reasons, we don't have to waste time on now. In Article 20, in Article 2, Section 2 of this Basic Law, as the German constitution, it says every person shall have a right to life and physical integrity. And the Constitutional Court said the state's duty of protection encompasses the duty to protect life and health against the risk posed by climate change, including climate-related extreme weather events. And it can furthermore give rise to a duty to protect future generations. So right here, the court says, out of this fundamental right, the state has a duty to protect future generations from the risk of climate change. But the court also said, we cannot ascertain that the legislator has exceeded its decision-making scope insofar. The legislator does not fail to pursue the goal of climate neutrality at all, nor does he allow climate change to simply run its course. So the judges said, yes, from a fundamental right position, future generations have a right to live and to physical integrity, and that's the first important sentence. But if we look what the legislator has done so far, we cannot see what he has done not enough. So we see that the legislator has still a decision-making scope, and the judges said the legislator acts within this decision-making scope. And furthermore, the judges said additional protection can be also provided in the form of adaptation measures in order to protect fundamental rights against the risk posed by climate change. So we say the legislator does something at all. He doesn't allow climate change to simply run its course. That's the first point. And the second point is there are also adaptation measures by which future generations can be protected against the risk of climate change. So up to here, it's quite disappointing, but it's not my last slide. The court also said that fundamental rights are violated by the fact that the emission amounts allowed until 2030 substantially narrow the remaining options for reducing emissions after 2030, and thereby jeopardizing practically every type of freedom protecting by fundamental rights. So the judges create a new figure of argumentation under German fundamental rights, the so-called intertemporal guarantees of freedom. The court says, as intertemporal guarantees of freedom, fundamental rights afford the complainants protection against comprehensive threats to freedom caused by the greenhouse gas reduction burdens being unilaterally offloaded onto the future. Yeah. So they say, legislator, you have done something, but only until 2030, and that's not enough. Now is the question, where comes the obligation to mitigation actually from? It's not in the first course from the fundamental rights, but it's Article 28, 20A of our basic law of our German constitution. Article 20A is not a fundamental right, but a general constitutional principle, and it says, mindful also of this responsibility towards future generations, the state shall protect the nature foundation of life. And from this general constitutional principle, the judges derive the obligation to mitigation. So Article 28 places the state under an obligation to take climate action and is aimed at achieving climate neutrality. The obligation to take climate action is accorded increasing weight as climate change intensifies. So the duty to act becomes even more severe as the climate change goes on. And then the court says, since global warming is a worldwide phenomenon, Article 28 obliges the state to involve the supranational level in seeking to resolve the climate problem. State cannot evade its responsibility by pointing to greenhouse gas emission in other states. One of the big excuses we have heard so far. Other countries aren't doing more ambitious actions, so we don't have to. And then there's another important point coming from temperature to budget. So as you all know, the Paris Agreement sets a temperature goal and not a remaining budget. And the court says right here, since the legislator itself has chosen to ratify the Paris Agreement, its obligations are the threshold for Article 28, to which he must stick now. So Article 28 as itself doesn't say climate neutrality or Paris Agreement, but as insofar as the legislator has ratified the Paris Agreement, he incorporated the Paris Agreement into the national constitution of Germany. So that's the argumentation. And when they say the constitutionally relevant temperature threshold of well below 2 degrees and preferably 1.5 degrees Celsius can in principle be converted into a remaining global CO2 budget, which in the next step can then be allocated to states. So we actually transfer the temperature goal into a remaining budget for the world, and in the second step for Germany per capita. And using the emission amounts stipulated in the Climate Change Act, the remaining budget calculated on the basis of the IPCC estimates would be largely used up by the year 2030. So the judges say there is a remaining budget for Germany. And if we stick to the Climate Change Act, German legislation has just passed, the budget is largely used up in almost 10 years. And that's why the court comes to the full conclusion. The judges say one generation must not be allowed to consume large portions of the remaining budget while bearing a relatively minor share of the reduction effort, if this would involve leaving subsequent generations with a drastic reduction burden and expose their lives to comprehensive losses of freedom. They say at some point in the future, even serious losses of freedom may be deemed proportionate and justified under constitutional law in order to prevent climate change. However, since the current provisions on allowable emissions amounts have now already established a path to future burdens of freedom, the impacts on future freedom must be proportionate from today's perspective. And furthermore, the court says Article 28 encompasses the necessity to treat the natural foundations of life with such care and to leave them in such condition that future generations who wish to continue preserving these foundations are not forced to engage in radical abstinence. And so the court comes to the ruling saying that the risk of serious burdens is significant and can only be reconciled with potentially affected fundamental rights if precautionary steps are taken to manage reduction efforts anticipated after 2030 in ways that respect fundamental rights. The court says it also requires initiating the transition to climate neutrality in good time. In specific terms, this means that transparent guidelines for the further structuring of greenhouse gas reduction must be formulated at an early stage, providing orientation for the required development and implementation processes in conveying a sufficient degree of developmental urgency and planning certainty. And here is the imperative under constitutional law that further reduction measures are defined in good time for the post-2030 period, extending sufficiently far into the future. Moreover, the court says, further annual emission amounts and reduction measures must be defined in such detail that sufficiently specific orientation for the future is provided. And right here you can see, if you remember my first slide, showing the gap between 2030 and the climate neutrality in 2050, the court explicitly says you can't afford as legislator to have such a big gap of 20 years where people do not know what comes next. And first of all, the generation living now is not entitled to consume the remaining budget in the next 10 years, leaving an even more bigger share or burden for future generations in the post-2030 period. So the court, in its ruling, said the legislator has to amend the Climate Change Act until December 22 by establishing a path for the periods beyond 2030. And surprisingly enough, the parties forming our government, so Christian Democrats and Social Democrats, they were somehow happy and eased reading the decision and instantly reacted, amending the Climate Change Act, even though it would be good enough to do it until December 22. They just did it the last weeks. So, and the amended act, the amended Climate Change Act of Germany right now establishes the goal of greenhouse gas neutrality not by 2050, but instead by 2045, 5 years earlier. We have a 2030 target of minus 88% greenhouse gas emissions, which was in the former version, not in the law. We have intermediate targets for 2031 to 2040, and we have yet indicative sectoral targets for 2035 and 2040. And the Climate Change Act right now says we will fix the period 2031 to 2040 in 2024, 1 year earlier than in the former version of the Act. And the final 5 years, 2041 to 2045, will be fixed in the beginning of the 2030. So we really try to stick to the ruling of the Constitutional Court, planning in advance, telling people in advance what comes next, and trying to make clear that the remaining budget and the burden for future generations is not postponed, but that we have to deal with that in our decade right now. Yeah, that is the decision of Germany's Constitutional Court in a nutshell. That's it for my presentation, and I'm happy to hear your comments and questions.
Yeah.
Thanks a lot.
Thank you very much, Hartmut. Maybe you don't have a lot of time, but I would like to ask you personally, have you been surprised by the decision, or did you await the decision, or?
I was really surprised, and a lot of my colleagues, our colleagues in our federations surely too. It was really a breaking news that morning that the Constitutional Court has decided that way, because you can say that the wave of successful climate litigation has reached Germany and wasn't predictable. That we had seen other decisions by minor courts rejecting such claims, and that's why it was really surprising.
Yeah. Okay. Thank you.
Yeah. Tobias, I take back over from you.
Yes.
From my side, also thank you very much, Hartmut. And then I would also like to refer everyone here to the chat window. So if you have any questions, please don't hesitate to write your questions, of course, comments as well in the chat window, so that we can also refer the speakers to that, or also, of course, discuss this at a later point of time. Tobias, you also here included a small survey, which maybe you can just retype that website, which you ask participants here to contribute to. Well, I think that was an excellent introduction into what the German Federal Constitutional Court has decided. Thank you so much. And what we already hear from you is that it's a huge breakthrough. It's changing somehow the way we've been looking at constitutional law, and will certainly have a long-term impact. What we expect and what we hope, of course, that this impact is not only within Germany, also beyond Germany. And that brings us to our next speaker. It's my pleasure to now welcome Dr. Dörte Fouquet, who's been working as a lawyer for many years as well, mainly from Brussels, on the one hand, as a lawyer for a law firm, but also as a director of the European Renewable Energies Federation. Dörte, you've been working, of course, a lot on law that is related to energy, but sorry. You have been working a lot on law that is related to energy, but of course you're also following closely in general the relationship between the German Constitutional Court and the European Court of Justice, which is, let's call it sometimes also a bit competitive. So I'm very much looking forward to hearing from you how you see that decision from the European perspective on the one hand, on the European level, but you also, of course, are aware of what's happening in other European countries. Dörte, the floor is yours.
Yeah, thank you. Thank you so much, Stefan, Tobias, everybody that I could jump in. And I'm very happy I could make it. I will have no PowerPoint presentation, but maybe later I put some things together and then I would share it with you also as a PowerPoint. You said there is a competition between the German Federal Court and the European Union. Yeah, there we have some maneuvers, or we have also some standpoints of the German Constitutional Court that something which is enshrined in our constitution, but which is not reflected that much. And in this aspect, in the European treaties, Germany can very well also look into European decisions under our national court ruling. So this case is a bit different. Yes, we were all, as was just said, we were all happily surprised by the verdict or by the decision. It's not a judgment, but we were also, but I personally, since another interesting case of the German Constitutional Court on sustainability and on well-being of the people and constitutional rules had been given under the questions around the phasing out of Germany from nuclear power, where the German Constitutional Court also made it very clear that there is the right of the state to reflect the meaning of the people and the general opinion that nuclear power is unsustainable and should be ended, and therefore effects on companies who run nuclear power stations have to be, to a large extent, have to be taken by them in our constitution enshrined responsibility. So that's insofar that the court now takes more and more, the Constitutional Court, serious the threats on people and the protection level of the Constitution is not surprising. It is nice, it's good, and it's important. On the European level, when I now first might talk about the EU legislation and the EU jurisdiction especially, we do have a complete different set when it comes to access to justice. I remember already, really, I'm an old trooper in Brussels, and 25 years ago, together with DG 11 Environment at that time, we had a program and a meeting and a conference on access to justice in environmental matters. And when I look back on this time, there is a little bit of success in some cases, but I would say the majority of cases where people, NGOs, acted against decisions of the European Commission or of the legislator, they were rejected as inadmissible. And also in climate litigation, unfortunately, we had a very recent decision from the 25th of March 2021. It's an appeal decision. So there had been previously decision by the General Court, and then now we have the appeal decision by the judgment of the European Court of Justice. It's a case where 36 appellants, 36 civil society, youth mostly, also appealed, went against or asked for annulment of the 2030 climate and energy package of the European Union, claiming that it is not enough. And please come back what our colleague Carlos just said, a similar reasoning. Also here saying, where's the accountability? And they had done a lot of things. But as so often, and I had also the displeasure to have those cases before the European courts in environmental matters, in energy matters for individual or for companies. And it is like a wall of brick. You run with your head full into that wall. And this is because the European court takes the very restricted view on access for those cases, and saying it can only be possible if you can prove as applicant that you are directly and individually concerned by the decision, for example, by the Commission, or here concerning the package by the legislator, and we always lose these cases. So it's very sad. I come back to another more positive thing, but this direct and individual concern criterion, all lawyers and all legal experts know. The plowman is the word, the poor guy. It was an old case about on duties in Hamburg Harbor. It's an ancient case, but there was the first time developed this criterion of a direct and individual concern. So that case, unfortunately, was not even the current case was not even discussed in substance. What we could do in Europe is to change this mechanism in changing the rules of the European Court, and changing that could be done within a constitutional convention and an amendment process. And the time is, interestingly enough, there, because in Europe we have now initiated under the pandemic hype in last year the conference on the future of Europe, and it's about how do we get out of this direct pandemic crisis, but it goes much beyond. And it is a bit, if there are French colleagues here, it's a bit the système Grenelle, like in France. So there will be a lot of discussion rounds via internet. You can make your voice heard. And I think us, the legal team here in this council, or also in other rounds, maybe with Zur Würzburg and others, we should think about bringing in some milestones and asking that the court acknowledges finally his role, which former Advocate General of the court, General Jacobs, had often underlined, and saying the court must recognize that he's also an administrative court and that he has to look into third-party claims, and he cannot always say plowman. And I could well imagine that we do have also in our treaty, in the European treaty, we have Article 11 and Article 191, for example, which the one is in the environmental principles of the European Union, and the other is climate protection. And then we have further articles. So we could say that when it comes to reflecting on those articles, this should be the direct concern should be taken in consideration in a way. Yes, I'm affected in my constitutional rights from the treaty. So that is an appeal a little bit to all of us to finally get over this bloody mess before the European Court. I might also say that Europe got a little bit red nose by the ESPO and Aarhus Convention, which is also an international treaty on environmental impact assessment, screening procedure in transboundary situations. And recently there was the decision by ESPO to tell the European Commission that we are infringing the principles of ESPO and Aarhus if we restrict access to justice for NGOs, industry, third parties, when it comes to state aid decisions by the Commission, which also affect environmental grounds. So we are a little bit, I'm optimistic there might come some movement now, and that this current High Court decision of the European Court of Justice, maybe a historic one, maybe I hope one of the last who just kicks people out when they just put their coat on the rack. But there's one thing, there should always be hope at the end, and I'm probably too long, but very, very briefly, we have another court in Europe, which is not a European court. It's the European Court of Human Rights in Strasbourg, where all European states are members, but there are also others, Ukraine, Russia. It's a much larger audience, let's say, as signatories to that European Court of Human Rights. And there is still ongoing a case introduced in 2020 by 6 Portuguese children and young adults. And they challenge the 27 EU member states, the UK, Switzerland, Norway, Russia, Turkey, and Ukraine, by arguing that they breach their human rights, also the rights of the people, of the youth, by failing to make deep and urgent emission cuts and not adequately addressing their contributions to emissions released beyond borders. And what is interesting in that case, many of the member states, the signatory states, thought the court will drag it out and will stop it. No, on the contrary, the court put it on fast track procedure and has already advised all the member states, and again, it's not only the European member states, to give their comments within a tight time period. So that case is running, and I'm very optimistic. And there are also now very important NGOs like Climate Action Network who have intervened on the side of the youth. So that will be also an interesting case. And coming back to what Tobias said in the beginning, 2 years ago, I think it was, there was once a report in a German public broadcast service, Deutsche Welle, where they had counted, and I don't have the source, but we might go back to that as WWR, that 900 cases at that time, 900 climate cases worldwide were on the go. So I think we have to thank our youth, but we also have to thank people who have always been dedicated to this cause, that we finally get a movement which in the legal field could mean an accelerated push to politics to come with tougher regulation and with instruments. So I spoke too long, but maybe it's due to I just got my second vaccination. Maybe. Sorry. Bye. Thank you.
Thank you, Deirdre, for your presentation. Stefan, are you still available or not? Yes.
Yeah, I am. Yeah. But it's up to you now. Introduce the next speaker. Thanks a lot indeed, Deirdre. I think that was also the cases that you just mentioned at the end. That is very exciting to hear about. I'm sure that is more food for thought for the future. Tobias, I mean, considering time, I just suggest that we continue. There's one question which maybe we can refer to at the end in order to stay on track time-wise.
Yeah, okay, fine. Well, then we continue with Carsten Bartol and André Lippert from the law firm Taylor Wessing. We've been working together with the legal working group and Carsten Bartol since 2014. Had nice discussions the last year. Our legal workshop during the wind energy fair at Hamburg, we didn't realize it due to the Corona pandemic, but I'm happy to see you here and with your colleague André Lippert. Yeah, you're working on energy issues. You're doing M&A transactions. Your colleague André Lippert is working on regulative issues. Feel free to start your presentation. Thank you very much. You're still muted, Carsten and André.
Always good if someone's watching me. Yes, thank you, Tobias. Good to be part of this seminar. I have the same question as you had, Tobias. How can I start our presentation, or where?
Sean? Yeah.
Okay. So we in preparation to this seminar, we had started to prepare slides, and we have of course before this had a lot of internal discussions and considerations on what the consequences of the Constitutional Court ruling in Germany would be. Therefore, the presentation is a bit longer, and we will in no way will it be possible to press this into 10 minutes of speaking about it, because there are so many potential consequences, so many things to discuss along the way to achieve the goals of the Climate Protection Act in Germany as it has now been amended. So there will be a slide. We will concentrate on some of the slides. I assume that the slides will be shared and can later be downloaded, so that also any follow-up questions from other slides might be of interest for you, and we will of course be happy to answer whichever questions you may have from that. I would like, with my part of the presentation, I would like to start with slide 6. Yeah, we have heard from Karl about the contents of the Constitutional Court judgment, and we have also heard, I've took some notes, that the court, or that the expectation is that there will be transparent guidelines for further structuring of greenhouse gas emissions, and that the Climate Protection Act shall procure for sufficiently specific orientation. I personally am not so sure and convinced that the changes in the Climate Protection Acts, which have now been implemented or which are now under discussion following the draft from the German government, are really specific enough. What we see here in a bit more detail in the table below on this slide are the targets which are allocated to the different sectors in German industry. And again, they are still only targets. They are not precise measures, and we will come back to this later. And if we had 3 hours time, we would still not even be able to cover all the precise issues that one could think about in implementing these targets in a reliable way. Next slide, please. So what will be, as you may have seen, the largest burden evidently is allocated to the energy sector. And we have already agreed in Germany on phasing out of the use of coal for energy production. We have concentrated, like many other countries had, on rather abstract targets so far. And as I have just said, the expectation is that there must come more concrete measures. However, we have so far not seen such concrete measures on the horizon. There's some discussion about the amendment to the Climate Protection Act, but we have not seen any movement, or I have not seen any precise movement in terms of what exactly will happen. And the energy sector, as a very conservative part of the German industry landscape, the energy sector is in a way left without any solution. They know they have to adopt to the new targets. They know they have to do something. Then the same applies. We have been speaking with the interest club for the German energy consumption industry and for intense energy consumers in Germany. And they are also saying we need to adopt to the change. We need to adopt to the new rules of the market. We need to know how to deal with green energy PPAs, etc., etc. But we don't have the environment. If you look at the last bullet point on this slide, this is a very recent publication I have read in the Internet of Berlin newspaper Tagesspiegel, where the energy industry urges policymakers to say what we need is 300 to 400% more in renewable energy, 300 to 400%. And we do not see that the legislative, or I do not see that the legislative environment in Germany so far has adopted any concrete measures, such as, for example, changes in planning law, etc., to achieve this goal. And this is a goal that must be achieved within a rather short period of time. Next slide. So the result is evident, and that's more or less other words for what I have just tried to say. What is evidently needed is an expansion of renewable energy production. Issues like joining the sectors will play a big role in it. We will hear a bit more maybe from Andre on, for example, on implications for the real estate sector, etc. But we urgently need much more new production facilities. For example, if you look at the third bullet point on this slide, it is said that what we need in wind energy onshore is five times the pace of newly built capacity compared to what we have now. Luckily enough, we have larger turbines. We're reaching 6 megawatt turbines for onshore wind, but we still use much too much of the time to have them permitted, to have them planned, and I don't know in which period of time erected. So this, I think, these I think are the main goals which have to be solved by policymakers. And again, I personally cannot see too much of this now in the amended Climate Protection Act, nor in other legislative activity at present, which may change once the elections in Germany are through and we have a new government. Next slide that I would like to concentrate would be slide 11, because I think that's individual claims, right? That's an interesting topic as well, and Dörte Fouquet has also mentioned it, how direct individual claims can be tied to the issue of climate change. And the Climate Protection Act, both in its current version as in the intended amended version expressly says that no individual right will be granted by virtue of the code. And this is expressly set forth in the draft legislation, so as to prevent private individuals or maybe companies or associations for climate protection, to prevent them from suing governmental bodies or federal states for not reaching the targets included in the Climate Protection Act, which being honest, makes the Climate Protection Act less of a piece of legislation and more a political declaration. It is still only a piece of paper with targets. And it remains to be seen how these targets will then be implemented by such concrete measures on which project developers, the industry, energy consumers, etc., can really rely on. Interesting in this context is, in fact, the court decision in The Hague. I believe it's now 2 weeks old, where Shell has been obliged, upon litigation initiated by private individuals, to reduce their carbon dioxide emissions. Very interesting case, and from a legal perspective, so far practically unheard of, that in fact a court in a European country awards private individuals a claim against a specific company to reduce carbon dioxide emissions. Very interesting to see that. And if we look at slide 12, this is a citation from a report on the judgment from The Guardian, where inter alia, the court, that's the second to last bullet point, where inter alia, the Dutch court has not only based its judgment on this article of the Dutch Civil Code, which I would not understand if somebody would show it to me, but which has also based it, and we have heard this from Dr. Fouquet in her presentation, which is also based on articles of the European Convention on Human Rights. And that blends into the pending court there at the Human Court for Human Rights, initiated by the Portuguese families that you have mentioned. This will be very interesting to watch, and it will also be interesting to watch how the reasoning of the German constitutional courts will be used in the future to base individual claims of private individuals or of companies against governmental bodies, and maybe even in the longer future against companies to submit and observe climate change rules. So, very quick run through some of the slides from my perspective, and I hand over to Andre, who will fill you in on some more of the expected outcome and consequences of the Constitutional Court ruling.
Yes, thank you, Carsten. Okay, Andre.
Yeah, thanks.
What's yours?
Thank you very much. Thank you for the invitation and for the possibility to be with you here today. As Carsten already said, I'm working with him especially on regulatory issues on the energy sector. And I've just a few thoughts on our topic. And as we understand it, the main question was the law implications from the ruling of the Constitutional Court. So I prepared some issues, some thoughts we could share and perhaps discuss, and it's only a few minutes. With look time, I see that I only have a few minutes. But I would like to start with the first slide to present our question, which we put at the beginning. Yeah, this or the second slide. This is the first. Yeah, this one. It's a really new survey of you already know the German Association of Wind and Water Industries, and this survey says, okay, from starting from the ruling of the Constitutional Court, we might see that decarbonization is hitting digitalization. So it was a survey between a lot of business who has been asked what their challenges for the future are, and they said it's no longer, and on the first place, digitalization, but more decarbonization. And this is, I think, and we thought, and we see it already, one of the main points, perhaps a more political point or more economic point, which are strengthened by the ruling of the Constitutional Court in Germany. There are 2 points at the end: long-term PPAs and guarantees of origin. This is very interesting because the surveyed business said, okay, 2 issues, 2 very concrete issues are of shared or important interest for our business model. And this is that long-term PPAs, from which we can get our electricity, green gases, will be more and more important. And as well, and this is very interesting for us as well, these guarantees of origin, which are the means to say that electricity is from green sources, will become more and more important. And I think these are 2 very concrete outcomes of the ruling, which are strengthened by the ruling. And as I already said, these long-term PPAs are not only for electricity, but as it said here, for green gases. And perhaps we can jump to slide number 9. Another, and this was my understanding of the task, another concrete idea which we have is that the ruling of the Constitutional Court will give wind, will promote the discussion on green hydrogen. The thesis we put there is that the expansion of the use of hydrogen is very at stake, is discussed widely, but the future challenge is to come from the pilots which are launched to the market launch. This is one thing, how Carsten had already said, the problem is that the targets are clear, but the means are still missing. And one of the means which we think in the future will be discussed more are these hydrogen expansion. There are some figures which we took on the slide, but the challenge is on the last box. And it says the challenge for the legislator in Germany and worldwide and European legislator is to create a legal framework that is safe and which provides a reliable basis for investments and to promote the market launch. We have a lot of pilots now, and we have a lot of 8 billion euros were granted by the German government a few days ago for this important project of common European interest. But we are still looking at the market launch in this area. And now we're discussing some kind of voluntarily opt-in regulation for hydrogen networks. This is one issue we are just discussing, or the EEG levy for electrolyzers. And we can see here that this decarbonization issue will be of more and more importance if we look at the implications of the constitutional ruling there. Another issue, and this is only one aspect I wanted to mention at the end, is on page or on slide number 12. This is not a first step. This number 12, the one with impact on environmental building and planning. Yeah, this one. Thank you. This is not at the first resort a question of energy law, but we see in Germany, as we discussed it in Europe as well, that it's especially the building sector who does not fulfill its requirements in the last years. We have this, I mentioned the German name there, the building energy law. This is a new law, and there have been a lot of discussions in Germany because there are no stricter standards compared to the preceding regulations. And this is astonishing because it's the building sector who is responsible for most of the greenhouse gas emissions, and it's the EU, it's in the last box, who has adopted a renovation wave strategy and is on the way to promote new regulations. But we are still discussing the concrete figures for the building sector. And my forecast is that this is one of the sectors who will face a lot more of restrictions in the future to meet the requirements which the Constitutional Court has mentioned with regard to decarbonization. On the last, and this is just to mention the last two slides. I'm not quite sure the last three. It's beginning with the next slide. Yeah, 13 on my. Perhaps you can see the next slide. Yeah, this one and another one. You can go on with what is expected. We have just gathered, and you can read it after our presentation. We have gathered a few examples of what is just right now discussed to meet the requirements of more decarbonization. And there are a lot of proposals from the different stakeholders, but this is, as I already said, one you could have a look into after our presentation. We just wanted to have a quick look at some of the issues discussed after the constitutional ruling, and that's what we wanted to discuss. And perhaps if there are any questions, please feel free to ask them. Thank you.
Yes, thank you very much, Carsten and Andre, for this presentation. I think we will upload the presentations on the website of the World Wind Energy Association so that everybody has the possibility to check this out. Yeah, thank you. What I really liked in your presentation was the hint that it's good to take legal action, but then in the second step we have to define how we reach the targets. And Carsten and you showed it that we need legal action for renewable energies, and then also hydrogen is quite interesting to fulfill the CO2 reduction. Yeah, and I think that's also up to us as the World Wind Energy Association to make proposals how we can reach the goals and how we can reach the CO2 emission reduction. Okay, thank you, Stefan. It's up to you, I would say.
Thank you, Tobias. Then let's travel a bit away from Europe. I think that was actually the reason why we decided to have this webinar at the time when we heard about the decision by the German Constitutional Court, and then we got kind of overwhelmed because just briefly afterwards we heard about the Dutch case, and we heard about an Australian case. But before we heard about the Australian case, we already got in touch with one of our experts from Australia, and I have the pleasure to invite now Jeremy Schulz, who is a lawyer in Australia, Finlay Lawson. That's the law firm Jeremy is working with. And what we became aware even before we heard about a decision by the Australian Federal Court was that there are many cases already going on in Australia with regard to climate litigation. And now it's my pleasure to welcome again Jeremy. Jeremy, you're with us, and I'd like to invite you to present us the cases from Australia, the situation in Australia, and of course feel free also to comment on what you've heard so far. Jeremy, the floor is yours.
Thank you, Stefan. I assume you hear me loud and clear, which is a good start.
Yes,
good.
We hear
thank you.
Well.
That's good. I'd like to thank you for the opportunity to present to you today on this important topic. And we've heard today quite a bit about the German Federal Climate Protection Act case, and I want to comment on that. I think at the outset, I'd like to say that it represents a major step towards worldwide recognition of duties of governments with respect to the impacts of climate change. I will show that whilst its direct application to an Australian setting is limited in Australia, the opportunities for challenge of government inaction in Australia are rapidly growing. So I have some slides, and I'm hopeful now that I'm doing a new share, and hopefully that will work.
I can see them, it's just not on presentation mode yet. So if you just click on that small button at the bottom.
Yeah.
Or you go to the slideshow and the menu.
Slideshow. I'll just go back again. So I've got a share.
We can see it, it's just not the presentation, but we see the small slides on the left side as well.
Yeah.
You can just go to the bottom on the right, and then it looks like a screen. Go a bit down, down, down.
Yeah.
Right, and then right.
Yeah.
Right. This is the one. Yes.
This one.
Yes.
Slideshow.
And it should work. Yes.
Oh, excellent. Excellent. Thank you very much. So I'm going to, this is just me. So you've heard a bit about me, and I don't think you need to know too much more other than I've been in this topic for 20 years and been part of developments with the Clean Energy Council in Australia, and I'm currently the Vice President of the Australian Institute of Energy. What I would like to do is to start with a very quick summary of current developments in Australia that I think are very much relevant to litigation and legal action in the country. In summary, recent developments include coal-based power stations being closed at an increasing rate. As an example, the owner-operator of the Yallourn power station in Victoria has recently announced that it wishes to bring forward the closure of the power station. It's currently scheduled for 2028 and negotiations are proceeding. Wind farms and solar farms are now being coupled with batteries and storage technology so as to assist with what's perceived to be system instability through what is a very long and stringy grid through Australia. Steps are being taken by energy companies and government to develop a hydrogen industry. So I was very interested in the comments from Carsten and Andre in the presentation before me. This is identified as a major development opportunity, both as a domestic production and as a major export opportunity for the country, particularly to countries such as Japan. It's acknowledged that any substantial export industry would need to be undertaken by or underpinned by clean energy generation rather than based on fossil fuels. In what is, for us, an exciting announcement, the chief regulator of the Australian electricity system earlier this week approved a major electricity transmission interconnection between the states of New South Wales and South Australia. This is expected to drive the development of a new wave of asynchronous renewable generation. On a negative side, there are new coal mines opening and sought to be opened. And the Australian government has recently announced a 600 megawatt gas generation project to be undertaken. And it's perceived that system security through this Australian stringy grid requires baseload generation as coal generators are phased out. Australian greenhouse gas emissions were reported earlier this week to have fallen 5% from 2019 levels and 20% below 2005 levels. While this may appear pleasing, the question is how much effect did COVID-19 have on these figures? There are no Australian targets with respect to emissions reduction, no federal government targets. There are soft state government targets generally set by way of policy at 50% reduction by 2030. So that's a backdrop of where the system currently sits. We have what I would call minor legislation in this area in the country. There was a Renewable Energy Electricity Act, which requires retailers to acquire a percentage of their electricity from renewable sources. The main environmental legislation is the Environment Protection and Biodiversity Conservation Act, which requires major projects to be examined from the perspective of protecting the environment. I'll reference this in a moment in discussing the Sharma case earlier, which I think, or shortly, which I think is the case that Stefan might have been referring to earlier. There's a Carbon Credits, Carbon Farming Initiative Act, which is based on a fund as the main mechanism to encourage Australian businesses to cut emissions. However, it's perceived on all fronts as being inadequate to reach 2030 obligations under the Paris Agreement. There's also a Reporting Act for big emitters. So I move on, and I think the most important part in the context of today's presentation is twofold. Firstly, the application of the German Federal Climate Change Act decision in Australia, and then secondly, what's happening in addition in terms of litigation. So from a realistic perspective, I would note to start off that the decision is unlikely to apply in Australia. As we have heard, the court found that the precautions specified in the Climate Protection Act were insufficient to prevent an initial lacking response that would necessitate drastic, burdensome action close to the time specified, and that this legislation constituted a contravention of fundamental duties of the state to safeguard the environment and the position for future generations. German decisions are, of course, based on a civil law approach, whereas Australian courts take a common law approach in interpreting the Australian Constitution and other statutes in connection with the Paris Agreement. The common law takes an evolutionary approach rather than a revolutionary approach to the development of the law, and it's based on the doctrine of precedent. The Australian Constitution and other statutes do not specify any duty to protect future generations, in contrast with the environmental duty under the German Basic Law, which I note that, I think it was referenced earlier, that Article 20A of the German Basic Law states very clearly, mindful also of its responsibility towards future generations, the state shall protect the natural basis of life by legislation and in accordance with law and justice, by executive and judicial action, all within the framework of the constitutional order. In Australia, there is no legislation to this effect and no legislation expressly addressing or implementing the Paris Agreement. So there's call it a misfit in terms of applying the German decision. However, the most interesting phenomenon for me at the moment is that despite those factors, there is a clear growing legal accountability for failure to respond to climate change within the courts of Australia. In 2020, Australia had the largest number of proceedings issued after the USA challenging decisions or actions of government in relation to fighting climate change. There are currently 19 cases concerning climate change listed in the Federal Court of Australia. Legislation such as sections 55 and 64 of the Judiciary Act make the executive arm of government subject so far as possible to the same legal liabilities as citizens. Now, the novel duty of care that has been found to exist in very recent times by the Federal Court of Australia in the case of Sharma versus the Minister of Environment is very significant. In short, Sharma and a variety of other underage plaintiffs, a common characteristic in litigation that is emerging, claiming to represent all minors, sought an injunction against the Federal Environment Minister from granting an extension of the Vickery coal mine. The plaintiff argued that coal mining at the scale contemplated by the mine would exacerbate climate change, causing harm to young people into the future. The challenge was made under two sections of the Environment Protection Act that I referred to earlier, and sought to establish that the minister had a duty to take reasonable care to avoid causing personal injury to children when exercising his ministerial discretion in approving the extension of the mine project. Most importantly, the court upheld and established this novel duty of care to avoid causing personal harm to children, which the minister was subject to. It was found that the minister must consider the interests of children when exercising any ministerial discretion in this area. Now, that case wasn't successful on all fronts. An injunction was sought and the injunction was unsuccessful. On the basis of proof, it was difficult to establish that the minister would breach the duty of care. So the challenge is still in front of plaintiffs and, in a sense, the courts to enumerate what factors would constitute a breach of a duty of care. However, it's pivotal that the duty of care was found to exist. There are a couple of others that I wanted to mention briefly before closing. Another interesting mechanism that's been adopted to challenge government occurred in the recent case of McVeigh versus Retail Employees Superannuation Trust. The plaintiff was a contributor to the Retail Superannuation Trust, which owed its beneficiaries information needed to make informed decisions surrounding management of the fund under the Australian Corporations Act. The plaintiff alleged that the trust did not adequately disclose its exposure to climate change risks to its beneficiaries and its strategies to address these risks. Whilst the court case was settled, the court acknowledged the public interest nature of the claim in a socially significant issue by issuing an order for the plaintiff's application for maximum costs. Of even more significance, may well be of potential significance, is a claim submitted last year in Kathleen O'Donnell versus the Commonwealth of Australia and others. In this case, 23-year-old law student Kathleen O'Donnell filed a claim in the Federal Court of Australia against the Federal Court and two government officials for allegedly failing to disclose the risks to the value of government bonds posed by climate change. It is understood that this is the first case in the world to deal with climate change as a material risk to sovereign bonds. The decision at this point is pending. The case could potentially be quite momentous, and we're very much looking forward to the decision being handed down. I would mention two other possible claims very briefly. An emerging basis of challenge, human rights, was referenced earlier, and that's an emerging basis of challenge in Australia. In the state of Queensland, the recently enacted Human Rights Act is being used to challenge a major proposed coal mine in that state. And the claim alleges that the project breaches a number of rights under the Act, including the right to life, the protection of children, and the right to cultures. And finally, but as interestingly as the other cases I've referred to, is a New Zealand decision last year. New Zealand decisions are based on the common law and have persuasive application in Australia. The recent decision by the New Zealand High Court to hear arguments surrounding a novel inchoate duty to cease contribution to climate change in Smith versus Fonterra Cooperative Group Limited would suggest that there may be a new duty established which could form a substantial new basis of legislation against governments. So, in summary, in the short time available to me today, my conclusions based on consideration of the area is that there are structural limitations in Australia on litigious claims being successful in this area that are not in place in countries such as Germany. However, whilst the common law is normally responsive and not capable of revolutionary change, there is a growing acknowledgement and recognition of new duties in this area, which are very likely to drive litigious action being successfully taken on a significant number of fronts. So we look forward to future developments in this area with interest and with some excitement. So with that, I'd like to hand back to you, Stefan, so that you can, I believe, introduce Janine now. Thank you very much.
Thank you so much, Jeremy, for this really excellent presentation. Not only relating to the German case, I think that was very interesting as well, how that could have an impact or not so much, but also for really kind of opening our eyes, not only in terms of going beyond the German case, but also the opportunities that you see, many different ways how litigation or could find a basis for action, for more climate action. That is indeed very interesting and somehow also very encouraging to see that there are several cases. We hear now from Australia, even from New Zealand. So we've heard now many cases beyond that German case, and that I think that is very good. And I hope that this webinar is also kind of can help to kind of bring together a little bit these approaches. We heard from 30 there are 900 cases around the world, and that these cases somehow people can learn from each other. Now, before we go to Janine, and already a great welcome to you as well, let's have a look at whether we have any questions to our legal experts here. And I see there was one that hasn't been answered yet from Sain that is related to the German case. And I would request some of the German experts we have here, whether anyone is prepared to answer that. Does the German court's judgment imply a probable tortious liability and a revised standard of duty of care for private companies if emissions traceable to them are out of sync with CO2 limits? Is the judgment restricted in scope to greenhouse gas, or in your reading, can it extend in principle to other pollutants not directly related to global warming but tied to other ecological impacts such as on water, vegetation and wildlife? Any such litigation in the pipeline to look out for? There's a lot in this question, and is there anyone, Tobias, Carsten, Andre, maybe Dörte, who would like to? I'm not sure. I'm sure not answer this completely, but comment.
Carsten or Andre, do you want to give your view on this topic, or?
I can.
Please.
Let me see if I can put my face in the camera. I can only provide the very high level comment, and nothing even close to a solution. I personally, I strongly doubt that we will, at least in Germany, we will, in a shorter run, see many possibilities for bringing individual claims to courts and successfully. As I said, it is not by accident that the Climate Protection Act expressly says there is no individual claim under this under the Climate Protection Act, and you would have probably we would have to take each individual measure that you're thinking of, and even more so if you look at the protection of species, you would have to take each and every individual measure through the whole chain of legislation, which can take years and years and years, and you will probably only have a judgment that you can then maybe bring to the Constitutional Court once the time period provided for in the Climate Protection Act has expired. There will be, in the current legal environment, I think it will still be very, very troublesome. Although, of course, nobody really, nobody is that's a big word. But I think very, very few people had really expected the Constitutional Court to be so clear in its judgment. But I do not think, I don't know, Andre, what's your opinion on that? But I don't think that this already means that under applicable German law currently, you have an individual right to receive climate change protection as an individual person.
Yeah, that's absolutely what I see as well. We discussed it in advance, so that's absolutely right. And we have to keep in mind that that the ruling was from 2030 onwards, so it's in the future, and the question of individual claims is one of the important questions from the legal perspective in this case. So I absolutely agree. Yeah.
What I could imagine is that the revision of the Climate Protection Act would yet again be considered unconstitutional on account of its being so vague. As I have shown in my presentation, there's a table of certain reduction targets being allocated to certain industry sectors, but evidently that's not concrete. That in itself does not help to reduce carbon dioxide emissions. How could possibly the energy industry reduce carbon dioxide if they are not permitted to erect sufficient on and offshore wind capacity and sufficient solar capacity, plus hydrogen and all the other items that will play a role in the mix? That's just not possible to do.
Yeah, we have also a participant, Mr. Franke, Johannes Franke. Would you be able to give your short comment if you want? We've been in contact last week or 2 weeks before, and you worked with Roda Verheyen, and you told me an interesting information about the case against RWE. So please feel free. It would be a pleasure to hear your opinion about this suing companies. You're still muted.
You are not muted, but we still can't hear you, unfortunately.
No?
Yeah.
Yes.
Yeah? Okay, so it was just the microphone. Yeah, I can totally comment on this. As Tobias said, I worked a bit with Roda Verheyen, so I have a bit of maybe a different perspective, and I am a bit less pessimistic about potential tortious liability, because that is what the question was. Like, tortious liability in tort law needs to be distinguished from the climate statute itself, I believe, because that, as you rightfully said, excludes any individual rights. However, it's another question if there can be a private liability under general tort law, as it was assumed in the Shell case just a week ago. This is an argument that you could also make under German law, because here as well we have open standards in tort law, which we can try to use in order to argue a private liability, basically using a similar approach as the Shell case did, and the court followed that, as we know. So I'm a little bit less pessimistic. However, I do believe that the judgment of the Constitutional Court does not give us too much in this direction, because the arguments of the Constitutional Courts, they do not argue with the duty to protect, but with the how do you say, with state measures that will come, that are that need to come in order to comply with the Paris Agreement, and that will impede our liberties here in Germany. So that argument does not really fit to a liability of private corporations. However, what it does say, and this would be a factor that one would have to include when considering whether there is private liability under tort law, in my opinion, is that there can be no trust by corporate emitters anymore, in that they will continue to be able to emit like they do right now, because the Constitutional Court said very clearly that measures need to be taken for constitutional reasons. And although those measures are very unclear right now, I completely agree with that. They still need to come. It's a constitutional duty to take those measures. And that undermines any trust those companies might have to pursue their business as usual. And that might be an argument from the constitutional case that might be used in tort litigation, in my opinion, but I'm speaking from the top of my head here. This is obviously a very difficult question, $1 million question, so to say. Okay, that would be my my comment on that. Thank you.
Yeah, thank you. Johannes, thank you for your opinion. Good. I think we tried to answer your question. Stefan, please go on.
Yes, I think indeed that was very good also to hear this these opinions here. I think that's exactly why we wanted to have this webinar, of course, to have such exchange here. And what we understand is that indeed this is just obviously beginning, no? But it seems to be getting a new momentum all over the world, no, maybe not all over the world, but in many parts of the world. And that now leads me to our final speaker for this webinar today. It's my great pleasure to welcome Janine O'Keefe. Janine, you have now the duty to speak as, after all these legal experts, as I think by education, you're an engineer. You come originally from Australia, so another Australian here with us, which is great. But you've been living the last couple of years in Sweden, where you've been one of those who started this, I call it the new climate movement, meeting Greta just shortly after she started her school strikes for climate, and then being one of those brains behind the Fridays for Future and also Parents for Future movement. Now, after you heard that, and of course we are all aware that many of those who brought those cases to court are coming from the climate movement, are coming from the Fridays, in particular the young generation, the Fridays movement. We are very much interested in hearing from you how you see this as part of the overall, let me say, strategy that the climate movement has. Of course, those demonstrations are an important part. Working with science is an important part, but it seems that litigation, legal cases have to be and are already a core part of the global climate movement. Janine, welcome to you. And now the floor is open for your remarks.
Thank you very much. Can you hear me?
Yes.
Hi. Thank you for a beautiful introduction. I am part of the Fridays for Future movement, and I'm also working and long-term member of Extinction Rebellion. My most probably the significant contribution is the work behind me with the map and helping people find each other, which is a key part in movement work. I was personally pleasantly surprised to hear 900 cases. So immediately I imagine 900 pins on a map around the world. So every litigator can find each other. Some of them will be obviously doing human rights. Some of them will be doing constitutional law. Some of them will be doing individual against shell. And they need to be able to find each other. And that's one thing I hope would be a step forward in building this movement of energy, of basically challenging the powerful, be it in the governments, be it in the very be it in the big fossil fuel companies, but also in other companies, which often use or rely upon mechanisms of oppression. And we need to find ways to bring that forward. And I must thank you each. I've been really very inspired, both by the German case and the Australian case. And I was very early inspired when I started the work with Fridays for Future. By the Children's Trust, which is an amazing work in the US. And there are, in Sweden, I would say we're actually well behind much of the work I'm seeing. Just recently in an XR case, the court ruled that let me just find the wording, that there was not enough, the situation was not acute enough for self-defense. So you could not do, you were fined for any action within Extinction Rebellion because the court said the climate is not acute enough. Even though the UN has declared climate emergency, the EU has declared climate emergency, Sweden thinks there's no problem. There's not enough of a problem. And therefore, we have many countries who have many ways to go forward in this work. And we have many activists who can actually reach into using the court to actually bring their cases forward and make it stronger. There is actually a student case here in Sweden. It may actually change legislation here. I hope it does. Sweden, just to give you a small understanding, Sweden has a climate law, but it is not in line with Paris. And the government isn't actually doing enough to be in line with the climate law either. It's statistically recently understood that the government is doing approximately half, which is needed for Paris. And let us not forget, Paris is often 2 degrees, not 1.5. And there's a significant difference between 1.5 and 2. And in fact, it's probably human extinction. We want to go for 1.5. And if we miss 1.5, we want to go for 1.51 and 1.52. And we want to stay as low as possible. So from a global movement perspective, this is a really challenging conversation. And there's obviously many people who've thought about this far greater than I have. So it would be great to have a bit of a brainstorm to understand how to bring the law forward. One of the dreams I've had for a long time, and this is just off the top of my head, but that every, let's say, year 9 class, one of their yearly projects was to take their government to court. Now, this is clearly would possibly require far more lawyers than are currently involved in the climate movement. But I think it is actually possible if we could actually sort of, streamline what is the process you take, what are the steps you take, and how do you actually go through those steps? Because there's many teachers who read this, would happily read in detail some of these court cases and work out how to buffer their students into this process. The key in this work, whether you're taking every class is possibly taking their government to court, is not the winning the case from my perspective. We need to turn the conversation into how many youth find a voice. That is the key thing. And if I refer to, even if we refer back to many of the brilliant comments in this in this webinar, but one of them was about we don't have sufficient solutions. Well, and maybe there's not enough wind, and maybe there's not enough solar power ready. But the truth is, our government has a requirement to take consumption down, to change our laws so people minimize their utilization. And that is the key aspect. If we don't have the technology, we must use what is normally known in the IT world as user case. As we change the user model, we change the system, we make the economic system work towards living within our planetary boundaries. Does that give you a few ideas? And maybe, Stefan, I hand back to you.
Thank you very much. I think, Janine, that was kind of excellent summary. But I think that case that you just mentioned at the end it's even not so much. I see at the moment we are not yet at the point that we wouldn't have enough wind or solar or anything. But that's what I also had hoped. I think we started touching it. Make governments removing the barriers so that we can use those sources. At the moment, is no problem. It's obviously less of a problem in some countries to build a new coal mine than a wind farm. How can that be? And what are the implications of such now jurisdictions, of such decisions? And what can we do to strengthen the impact that this kind of decision diffuses, for example, into the energy sector? Or of course, we know that agriculture at the end of the day is also, and other sectors are also involved in and also need to change. So I think that is where that networking makes a lot of sense. People are aware of what's going on. They have the right information. And that's why I also mentioned to you, next to the social movement, it's also important to, of course, work with science and to work with the right experts and the right people. And for me, it's, by the way, also so great that we have now, I know in Germany, there's also lawyers for future. I'm sure that exists also in other parts of the world. You have psychologists for future, you have artists for future. So many professional groups are now willing to contribute to all this.
Absolutely. And I honestly think what you see here is that you got this group was really a movement in itself. Wind 15, 30 years ago was actually a movement in itself. And then it's actually grown now to encompass and bolster the law process and in our last webinar, where you actually talked about community groups creating new energy, that is actually in many ways a grassroots movement. And that, so the structure and the way to actually build together is fairly similar.
Tobias, I see your hand is raised. Would you like to?
Yeah, thank you, Jenny, for this inspiring comment. And I really liked your phrase. It's not about winning the case. I think it's, well, you try to win and then you lose, but one day you will win. And I think it's about spreading the word. What we are doing today, and just a small from me, well, it's history, but when I was a student in 2003, 2004, I was member, and I'm still member of a small German solar association, and they said, we should forbid the use of coal. And even me, as I liked Hermann Scher and renewable energy, I said, whoa, that's really a hard approach to forbid the use of coal. But finally, from 2004 15, 20 years later, Germany forbid the use of coal and decided to phase out of coal. So I would like to encourage our friends from Australia to think also the unthinkable, that, well, at the moment you're earning money and the coal industry is very strong, but I think it's possible also to use the coal use. And just the last phrase, I like a phrase from the former energy minister from Saudi Arabia who said, well, the era of stone, the age of stone didn't end because there were no stones, but because humanity, well, decided that they can use something else, which is better. And I think we are also in this phase where we know that renewable energy is better than fossil fuels, so we should just do it. Yeah, thank you.
I fully agree with that. And if I work on your comments to the next step, I think we can actually move forward with this process, because for example, in Australia, you have 70,000 or 150,000 students screaming on the streets each time. And Australia was the first ones to do the November 30th, 2018, with 15,000 students supporting Fridays for Future and School Strike for Climate. They are strong, they are brilliant, and people are listening. And just like if we think about the gay movement, one of the judges said, I can't judge against this person, because if I go home, my grandchildren will slaughter me. So let's use that power. Each judge has a family.
Yeah, I think that is a kind of almost concluding, very good concluding remark. When I look at the time, it is time to wrap up, unfortunately. Although this discussion is certainly something that we should continue. And Tobias, now we are going to prepare further sessions on this for sure. I think that, well, as I said before, this webinar, you can see that it's live broadcasted on YouTube. It will be available after, I think, some time. YouTube takes some time to then make it available. We will, of course, certainly share the links, and also those presentations will be uploaded here as well. From my side, thank you very much to all of you, particularly our speakers, for inspiring, very knowledgeable presentations that we heard today. That we're just able to touch upon this issue, but I think it's a very important topic, and it's a new momentum, and we're going to continue working on that. With this, I would again say thank you and goodbye, and for the final words, hand over back to Peter. And let me say, those listening to us and joining, like Peter, but also Jeremy, of course, in Australia, a great thank you for staying with us at this time of the day. It's quite late there. Peter, the last words for you.
Yes, thank you very much, Stefan. And thank you very much to all of the speakers. It's been a very interesting and a very educational, I think, session. It's one in which I've been stimulated to add another suggestion. And just very briefly, something which is working quite well in Australia is that the Australian Securities and Investment Commission and some retired judges and other people are talking about the issue of whether it's negligent on the part of a company director to the board of a company to not have regard to measuring what might happen to that company as a result of climate change. And I think that's probably going to be the one which is going to force more change more rapidly. And already we see that the major big business organisations are changing, and changing very rapidly. They're coming out in support of climate measures. They're coming out in response to the suggestion that it may be negligent, and probably is negligent, for them to not have due regard to protecting their investors' money by taking appropriate measures to protect against climate change. So with that added bit, can I say to everybody, thank you to those who've organised, thank you to those who've participated, and may we all go forward in achieving the sort of objectives that we've talked about in this session. Thank you very much.
Have a good night, have a good day, have a good afternoon, wherever you are.
Thank you. Bye.
Fairly well.
Bye.